for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
The poo-poo case.
Oh, brother, that one.
All I got to say is one thing, and I have been an attorney for quite some time. I'm getting older now, and I have actually know of a civil, and Todd's looking at me. Todd, we can't get in detail. You understand that. Promise.
I know.
Todd and I know of a case where there was a pooping problem that came before a judge. Now, let me tell you.
What?
Yes, this is actually true.
I've read the transcript.
I've read the transcript too. And I'm going to tell you, one of the questions by Your Honor was as follows. Well, it depends. How do you know that it was? Well, I'm going to back up and take a break, and we'll be back and talk about the pooping case. We'll be right back.
You know what? I got this all wrong. Keep going, Fred.
Oh, you want me to keep going?
I turned the flap the wrong way.
Oh, Cal
Please
just said we're out. Right, let's see. We got.
We're not. I lied.
Okay, we're good. So anyway, long story short, the judge asked a question. So the defendant's up there saying, well, there's no proof that was what it was, the little poo-poo.
Excretion.
It's not. There's no proof of that. And the judge said,
This is so gross.
Well, officer, and there was a police officer up there testifying, there's a smell factor. It looked like it? Did it smell like it? I was waiting for the taste part, there's an olfactory. The word olfactory was used. Could you tell a smell? And the officers, you could just see the officer on the stand giving this look like, really? But the officer's like, Your Honor, it was pretty obvious what it was. And it just, so this is not unusual, but this one's in Massachusetts we're going to talk about. And that transcript, Todd, you and I have read, is the most interesting thing to determine whether or not this individual was at fault for pooping in public. And by the way, we're not talking about San Francisco right now because it probably happens every day. And we'll be back and finish up with the Massachusetts serial pooper. And unless Todd wants to talk a little more about this one that he and I have read the transcript. I'm Fred Penney, your host, Radio Law Talk. Come on back.
And by the way, if you're eating breakfast, we apologize to you. But anyway, there's much more of Radio Law Talk coming up right here as you listen.
Now, let me tell you what happened.
Yeah, please.
So he goes on and talks to her. Apparently this had happened on at least, according to the owner of the store, 8 separate occasions. And they thought at first it was just an animal, in fact, a bear or something. And they thought, but what gave it away was the toilet paper and the wipes. But I said to but look.
Wait a second.
Yeah, I've seen
the commercial. The commercial. I don't know the brand, but they have the bears that are.
It's the soft one. What do you call it? I don't know.
Like a Charmin or whatever.
No, it's not Charmin. It's one of those really soft ones. It's got the little bear.
Yeah. Anyway, the point is that the state of California, by the way, is now looking to ban those air quotes disposable wipes.
Oh, okay.
So what couldn't have happened in California is my point.
Let's not talk about California. That's another discussion.
Well, I was just saying.
Yeah, I know. Okay. So, but anyway, what happens is, and then she just says, look, and now what we talked about, what do you charge? What is the charge? Every state's different, but here, what they're charging is 8 counts of wanton destruction of property. Okay.
Well, you got indecent exposure.
Well, no, she's behind the door of her car. I don't know, Cal.
And that is a good point. I'm glad you said that, because indecent exposure is not just the showing of genitalia or things like that, and this might segue into our Utah case here. That is, it's not just that. There's usually a component in the laws that requires that it be done for some sort of sexual gratification, either for your arousal or the arousal of somebody else. And so this wouldn't necessarily apply. I remember back in the day, I had a case when I was a young prosecutor. Well, let's just face it, I was never young when I was a prosecutor. But
keep this G-rated.
When I was an early prosecutor, and this guy was on leave from the Navy. And you know the show Jack, $, Johnny Knoxville?
Jack Bum.
Well, he wanted to make a video like that. And so he went over to a local putt-putt golf place right when the kids had gotten out of school for graduation, and decided that he was going to run around, streak through the golf course with nothing but a well-placed sock. Okay? Well, people chase him down. He gets back to his car. The cops show up. He gets arrested. We had a hard time figuring out what to charge him with because it wasn't doing it for that. It was in California, they have a public nuisance code.
Right. And it wasn't indecent exposure.
No, it wasn't indecent exposure. It was just a public nuisance is what they did. But a lot of cities have municipal codes that will result in a violation.
Right.
And I think that's what happened in Massachusetts. I know in California, in San Francisco, for example, where they do have an issue with this, it's in the news with people defecating in public. The city has a municipal code that the police enforce.
Okay, well, let's talk about what her defenses are.
Yes.
Okay? We're going to jump 855 Law Radio if you want to talk about her defenses. The defense would be what? The defense is
I had to go.
I had to go. And guess what her defense was? She has, and apparently legitimately, irritable bowel syndrome. And she can't wait. And by the way, you know what she does for a living?
Yeah.
Oh, Cal, ready for this? She's a nanny.
Yes.
Okay.
What?
Yes, she's a nanny. And so she claims and
Does she
argues.
teach potty training?
I don't know what she teaches. But irritable bowel syndrome. But, of course, the prosecutors come back and say, and the owner of the grocery store said, well, we have bathrooms for you. You can use our bathrooms, and they're available to the public and why don't you come use it? But she's going to argue my irritable bowel syndrome. It happens, and I can't wait.
And here's what cuts against that is the fact that the officer was observing this happen and observed her waiting in the parking lot. She wasn't very far from the house that she nannies at. That's one factor that the prosecution's going to have. Two, again, like you said, her employer said we had no restrictions for her using the bathroom. And three, the officer watched her wait for the parking lot to clear. Now, if you have IBS, and it's one of those.
What's IBS?
Irritable bowel syndrome. I've got 15 seconds to get to a toilet or there's going to be a mess. That's one thing, but she sat there and waited for the parking lot to clear, and that would have been plenty of time, they'll argue, for her to drive home.
Would they also not offer the thing of this was in a retail environment, so there may have been some stores where she could have gone in and used the restroom?
Absolutely.
Well, that's what they said. That's what the store owner said. But the other issue is that this is not like the first time. I could see if it was okay, it just happened. But this is a multiple occasions. This continued to happen and occur over and over.
Always at the same spot.
Yes, and that's why she's an SP. They call her an SP.
What's that?
Serial pooper.
Serial pooper.
Yeah.
Well, look, let's not discount the fact that when it comes, there are people that just once they get a spot they like, that's where they're going.
There's SPs.
Usually, it's in your own bathroom.
I have an SP with my bathroom all the time.
Yeah, yes. SP's anonymous. Hi, everybody. My name is Todd, and I'm an SP.
Hi, Todd.
I have kitties, too.
It's been 3 weeks since my last public bowel movement.
Oh, man.
Now, if you live up in the mountains...
I asked my nephew to pull my finger, but I called my sponsor. They helped me through it. I'm good. So... go on.
Without Denise here, we just can go on. Todd, you had another. Okay, about the one that you and I read the transcript. You had another point. Part of the. We're still on this, but we're gonna backtrack to the one that you and I know about. Well, so what was the one point you brought up?
The other thing in that was the transcript. This is going back to the judge who was describing the defecatory material left and whether or not they had probable cause.
It was near a library or something, or near a building.
Yeah,
it was right on a building.
It was in a
sidewalk.
public building,
yeah.
And the court opined that it could be mistaken for a chocolate candy bar.
Exactly right.
And when I read that, I was thinking,
I read it too.
He must have just watched Caddyshack, okay? And so, but this isn't in a drained pool, and it wasn't a Baby Ruth.
And it was not on film.
No.
And it wasn't the 70s where that was typical slapstick comedy,
Yeah.
No, and that's exactly what it said. And can you see, I just can still see the prosecutor and the officer just scratching their head going, what am I doing? Why did I get into this?
Well, what's the defendant? Does the defendant have no? Was she like being embarrassed or anything by all of this?
No, the thing is, and actually they had a public defender defending him. In this case, I think they actually found him guilty, but of a lesser account. From what I remember, it was a lesser account. So my point is, we're making here, Todd, and not myself and our producer Cal Hunter, do not be an SP. It's very important that you use the public toilets, unless you're up in the middle of the mountains and you can't help it.
Do you think the public defender was also doubting his career choice at that particular moment?
Well, when the judge wondered and asked the police officer if what the olfactory and the word olfactory came out situation was whether or not there's evidence. So
go to the website radiolawtalk.com. That's radiolawtalk.com.